All right. We're going to talk a little bit about the sources of law, because when we put together a really good predictive brief or persuasive brief, we're not going to just look at court opinions. Those are precedential, yeah, but there's a lot more law that goes into it. And there's a lot more avenues of research that you're going to need to know and that you're going to need to use in terms of crafting a really good argument on behalf of your client. So we're going to do a little schoolhouse rock, and we're not going to talk about how a bill becomes a law, just sitting here on Capitol Hill, but we are going to talk about the three branches of government. And I'm going to abbreviate. So the three branches of government, the legislative, the executive, and the judicial, give us our laws in a way. It's different in all three of these. So the legislature, we have Congress, and it works the same way in the state system too. They're both, because the court system and the government is organized in the same way. We have a legislature, we have an executive, either the president or a governor, and we have the judiciary. So we have the same three. They make laws, except for this one. The way that an executive might make law is that they really don't. What the executive branch can do is sign an executive order. Those do not create law. They are not allowed to create law. And sometimes when an executive does that, they get fought and it goes in front of a court, usually a Supreme Court at some point, and the Supreme Court said, no, that's more than you can do. You're actually making law. You can't do that. An executive order says how a law can be carried out. So they usually reference the law that they are talking about if they're drafted correctly. An executive order, let's talk about Kentucky with Governor Beshear, who just last week issued an executive order requiring masks to be worn in K-12 public schools. There was a law on the books for health and public safety that he said, here's how I'm going to interpret that law. Here's how I'm going to execute. Here's how I'm going to say this law is going to be executed. We're going to execute this law protecting public health by wearing masks. If a court were to look at that and say, well, no, that actually created a law, then the executive order would go away. If a court looked at it and said, no, that's within your executive powers, then it wouldn't. That's the extent of it. There's not much there. The judiciary interprets laws, remember? You should remember this from way back in the day. The judiciary makes opinions. So when a case comes in front of a court, they are going to issue an opinion. The opinion is just what they do. So let's say I have a motion to suppress in a criminal case, and I have filed one on behalf of my client. The court would look at the law. We would hold an evidentiary hearing, and then the court would issue an opinion saying either yes, the evidence is suppressed, or no, the evidence is not suppressed. These are the opinions, especially the appellate court ones, that you're going to research on Lexis and Westlaw that hold precedential value for your particular jurisdiction. Legislatures have two main ways that they create laws. They create, just like when you introduce a bill and it gets argued back and forth in different chambers and it gets passed ultimately, they create statutes. Sometimes they're called codes, sometimes they're called public laws. In Kentucky, they're called the Kentucky Revised Statutes. In Indiana, they're called the Indiana Code. A constitution would also be an example of something that the legislature can do. But these are the things that are written down and published, and usually once a year new laws are come into play. In Indiana, it's every July 1st new laws take effect. And one that took effect, I think 2 years ago, was no smoking in the car with kids. It was enacted sometime maybe in October, and it didn't go into effect until July 1st, so that the word could get out and people could get notified. And so they're easily searchable online for free. You don't need legal software to do that. And these are all things. If you ever hear that something is codified, if it's codified, then that means it's written down in a statute or a code. Now, the other way that the legislature can make laws is through administrative agencies. So, for instance, Indiana has a really lengthy Indiana Administrative Code. The legislature passed it. Now, your Kentucky experience is going to differ because, as I understand it, you have administrative law, but it hasn't been like republished in a long time. So what it is and where to find it, your mileage may vary. Professor Metzmeyer is an expert on this, and he can answer questions in advanced legal research about how the fact that Kentucky just hasn't done what they're supposed to do. But let's take Indiana, because that is one thing that the Hoosier State has done well. We have a very lengthy administrative code, the Indiana Administrative Code. It's a full section on the bar. And what it does is it establishes certain administrative agencies. What's an administrative agency? DCS or CPS, Department of Child Services, Child Protective Services. That's an administrative agency. Because remember, these are federal too. The EPA, Health and Human Services. There's a bunch of different administrative agencies. And so when the legislature creates one, they create some power for that agency to create its own internal rules. Now, does that always happen seamlessly? And does it never ever conflict with the statutes that the legislature has already passed? Nope. So we have a quagmire in some cases. And I'll tell you very briefly, when I was a family law intern in law school, I represented a firefighter and a Sunday school teacher that were accused of child abuse by the Department of Child Services. They were arguing a finding, and so it was an administrative finding of neglect. Now, you can have an administrative finding of neglect here with DCS. You can also have a statute that makes child neglect illegal. Can the same conduct violate both of these? Yes. What is the DCS worker bound by? Typically, both the administrative agency policy or rule and the statute. In this particular case, this Sunday school teacher brought her kids in. This little girl, she was about 3 or 4, and she ran headfirst into the corner of my desk and kind of bounced off of it, and then just kept bouncing all over the office. And I remember I was like, "Oh, is she okay?" And she's like, "Oh, she's just a tough little girl." And what had happened was they were playing, getting dressed in the morning, and Mom was tossing her on the bed, kind of a 1, 2, 3 go. And her arm got caught underneath her, and she fussed a little bit, but she didn't cry and she didn't scream. And she fussed for a couple of days. Mom took her to the doctor, and the doctor found a spiral fracture. Now, a spiral fracture can come from someone twisting that baby's arm. And in Indiana, everyone is a mandated reporter of child abuse. If you know of child abuse or suspect it, and a break would qualify, you have to report it, or it's a Class B misdemeanor. Well, the doctor did, and it was determined that no law was broken because there was a statutory definition of abuse that said if it's an accident, it's not abuse. And the doctor said this absolutely could have been an accident. I don't believe there were no bruises. It wasn't like you could see fingertips and breaking. The doctor believed the mom that it had happened accidentally. There were no other instances of abuse or neglect, nothing. So she was not charged criminally for child neglect or child abuse. DCS, however, had a different set of rules. And in their administrative rules, there was literally nothing about an accident. Unfortunately for that DCS caseworker, she had a second-year law student working on the case, and I wasn't about to go in front of an administrative hearing without like 6 feet worth of paper printed out, and I had done all of my research quite literally. The administrative agency had rules that essentially did not say anything about an accident. It said, well, we can issue a finding of neglect regardless. And during the litigation of that hearing, I had the statute with me, because DCS is bound by both. So in that particular instance, because she was only looking at the internal agency regulations, which are codified. You can find the administrative code. That's one of the issues with Kentucky, is not having that published like they should. But in Indiana, the administrative code is all published, and you can find those administrative regulations. She didn't look at that definition of accident, and so she admitted on the stand that she didn't even consider that it could have been an accident because under these regulations, it didn't mention it. I'll give you one guess who won that case that day. Because I knew both, and you must know both as well. This quagmire here, the administrative code, can be difficult to understand because it is written internally by the agency under the power that the code gives it from the legislature itself. So when we talk about opinions here, these rarely make law, but they can. This is called common law when we have law that comes from a judicial opinion. When we have law that comes from a legislature, we call that civil law. Now, opinions today typically are here to interpret law and not make it. But historically, judges made law. And so whatever law was what the judge felt it was when he or she, or he, let's be honest, woke up for breakfast that morning. That's what they decided what the law is, what the law was. It was spread by word of mouth, so it was really unreliable. It was even more unfair than life is today. And so most systems are now civil. But as recently as my practice in the state of Virginia, starting in 2000, all of our criminal definitions were common law definitions. I remember trying a robbery case and trying to look up the statute for robbery. Well, we didn't have a statute because our common law had not been codified. I had to look in judicial opinions to determine what the law for robbery was. And if you think that doesn't make sense, try burglary. Burglary is even more difficult to understand. You don't think so, right? Burglary is not that hard. Well, it is. Indiana has 5 different burglary statutes alone. But if you can't just pull up a statute and look at it, you have to do all of the research to find all the different cases to find what battery or what burglary is in 6 different contexts. That's difficult. Since I've left Virginia, they have now codified or put into statute all of the common law definitions of all of their crimes. But typically courts do not create law, they interpret it. There are some exceptions to that you'll learn in civil procedure. But these are the sources of law that we have. There are a few other ones down beneath here. There are some like municipal codes. Municipal codes are written by municipalities under whatever power the legislature has given them to do that. And so they're things like don't spit in public or smaller things like that. But these are all the different laws that you can look at when you're trying to find out the answer to a legal question.